Good morning. I'm Gary DeWaal, and this is Bridging the Week from May 2nd to 6th, and today is May 9th, 2016. The Financial Crimes Enforcement Network has finalized rules that will impose new due diligence requirements on banks, broker-dealers, future commission merchants, mutual funds, and introducing brokers when opening new accounts for legal entity customers. In addition, the New York State Department of Financial Services has approved the trading of a new digital currency, Ether, on a previously approved cryptocurrency exchange. I just got back late Friday from the annual FIA Law and Compliance Conference in Baltimore, Maryland, so I can review all the good handouts and get my work done today. Let's get started. The Financial Crimes Enforcement Network finalized rules requiring certain financial institutions, including banks, broker-dealers, futures commission merchants, introducing brokers, and mutual funds, to identify the beneficial owners of their legal entity customers. FiNCEN also adopted rules making explicit the obligation of covered firms to understand the nature and purpose of their customer relationships in order to develop customer risk profiles, as well as to conduct ongoing monitoring for reporting suspicious transactions and, on a risk basis, maintaining and updating customer information. Under FinCEN's new rules, covered firms must establish and maintain written procedures reasonably designed to identify and verify the identities of beneficial owners of legal entity customers unless such customers are expressly excluded. Beneficial owners include each individual who directly or indirectly has a 25% or more equity ownership interest in the legal entity customer and a single individual with, quote, significant responsibility to control, manage, or direct a legal entity customer, including an executive officer or senior manager or any other individual who regularly performs similar functions, end of quote. Legal entity customers include corporations, limited liability companies, partnerships, and other similar business entities. A covered firm must evidence its compliance with FinCEN's new requirements by obtaining a mandatory certification form from a legal entity customer that identifies its beneficial owners, or by receiving the information required by the form by another means with an appropriate certification. FinCEN's new requirements only apply in connection with the establishment of new accounts and will not ordinarily apply retroactively. However, a covered firm may have an obligation to obtain beneficial account information for an older account if concerns about that account arise during ongoing monitoring. Covered firms must comply with FinCEN's new rules beginning May 11, 2018. FinCEN, as you know, is part of the U.S. Department of Treasury. The New York State Department of Financial Services authorized the Gemini Trust Company to offer the trading of Ether, a new digital currency, on its virtual currency exchange based in New York City. In October 2015, the New York State Department of Financial Services granted Gemini Trust Company a charter under the New York banking law to operate a Bitcoin exchange. Ether is a cryptocurrency like Bitcoin whose transactions are recorded on a blockchain known as Ethereum. As a condition of its charter, the Gemini Trust Company is required to comply fully with New York State Department of Financial Services BitLicense regulatory framework. The Financial Industry Regulatory Authority issued a reminder to members regarding their obligation to timely report large options positions to the Large Options Position Reporting System as required by applicable rules. That system is commonly known as LOPR. FINRA requires members to report or have reported on their behalf any options position in an account where the firm has an interest and each customer, non-member broker, or non-member dealer has established, whether alone or in concert, an aggregate position of 200 or more option contracts, whether long or short, of the put class and the call class on the same side of the market for the same underlying security or index. All positions must be reported to LOPR by no later than close of business on the business day following the day the transaction or transactions happened that necessitated the filing. And finally, the Commodity Futures Trading Commission approved the final rule to make clear that swap dealers and major swap participants must only exchange the material terms of swaps in connection with their ongoing obligation to provide swap counterparties with data to reconcile their swap portfolios. Material terms include only minimum primary economic terms as defined in the CFTC's rules. The final rule is generally consistent with prior staff no-action letters. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. Until next week, I'm Gary DeWaal. Ciao.